Laws we make them, right? Like state laws that countries create, are created by people. And they're created to reflect the needs of the time.
Welcome to The Feedback Loop, a Sino Global Capital podcast where we keep you in the loop about the most pressing issues in Web3 today. I'm your host, Mona Hamdy, a Harvard teaching fellow with 20 years of experience in nonprofit and sustainable development. I started using emerging technologies 15 years ago, working with remote peoples to create new economies based on the reversal of climate change. And today, I'm the Chief Strategy Officer at Sino, where I hope to bring beneficial technologies to the most forgotten corners of this planet. Today, I am joined by my dear friend and crypto attorney, Stephen Palley. With over 20 years of practice involving complex commercial matters, primarily disputes, Stephen has focused nearly exclusively on the digital asset space since learning about Bitcoin approximately 10 years ago while he was developing a dispute resolution software platform. Hey, Stephen.
Hey, what's happening, Mona?
How's it going? How are you?
Fat and sassy.
I think it's kind of interesting that you thought guppies were ridiculous, but now in the past few years of your life has been involved. You've taken a few animals and a few sort of mythical creatures, I think, seriously through formation, through new areas of crypto law. So it seemed kind of...
I'm not sure. I'm not trying to, I hope anybody who needs a lawyer and who listens to this thinks of me. But honestly, a lot of the stuff that comes in, it's not that I laugh at them, but we turn away 80% of the stupid dipshittery that comes in because it just doesn't make any sense. And that's the challenge with crypto. And I think it's fair to say this is true of most new technology or frankly, most business. You have to be able to hear the signal through the noise, right? And most of what comes in, all seriousness, setting aside dumpster and herring jokes, most of what comes to us is noise. And I don't know. I guess I'll deal with noise if the client's honest and they don't want to break laws, but it's tedious. The interesting stuff is the signal.
So speaking of signal, you've had a pretty interesting, I think the whole market's been, it's been a really interesting 6 months, but in terms of signal and where it relates to your point, things that might advance the market outside of the dipshittery, you've had a pretty vocal stance on regulation and on policy, on what it means to be something that might be considered a new technology that already has established precedent. Where are we today, do you think, when it comes to this sort of signal to dipshittery ratio?
You hear a lot of people complaining about the SEC, quote unquote, regulating through enforcement. And I have kind of mixed feelings about that. I think our securities laws in the United States, first of all, bear in mind, too, for people who are outside the United States, I'm an American lawyer. I really only know American law. The SEC has broad reach, so does the CFTC, but a lot of our laws came about, after the Great Depression. So the Securities Act of 1933, the Exchange Act of 1934, the Investment Advisors Act, the Investment Company Act of 1940. Those were in part in response to excesses in markets that led to the Great Depression. Now, there were investor protection, there were statutory regimes in place at the state level, and a lot of what U.S. securities law arose out of or came out of was English law. There was an English securities law statute that the 33 Act and the 34 Act in part were designed to be modeled on. But what's interesting is that the SEC, originally, our securities laws were going to be controlled by a consumer protection and antitrust regulator, the FTC, and it's sort of at the last moment-ish that changed. Now, that's a long digression. Laws we make them, right? State laws that countries create, are created by people, and they're created to reflect the needs of the time. And our securities laws are the outgrowth of a period of time when there was a thought that providing consumers with disclosures about companies and about stock they were buying would make sense. And holding people accountable for providing inaccurate disclosures would make sense. Now, the question is whether or not that disclosure, reporting and disclosure regime makes sense with respect to software. I have this idea that nearly 100-year-old statutory regime probably doesn't make sense for certain types of software, where the risk inheres in the code and where the code can be examined, perhaps publicly, I think what we'll see is maybe a change in regulation over the next 10 or 20 years. These things happen over a long time period, but I'm not convinced that securities laws are purpose fit for regulating things like peer-to-peer trading, automatic market makers, liquidity pools. That said, there are certainly arguments that those things fit into existing regulatory regimes. I don't think that things like a true DEX, where you have smart contract code deployed on a blockchain, I have a hard time seeing how that fits within the definition of an exchange under the Exchange Act, but you can see how someone might take that position. So I think the problem is largely the laws and the regulations that derive from them don't necessarily make sense when applied to certain software. Whether or not they do apply is a different ball of wax. The thing about the arguments about regulation by enforcement, unfortunately, that's the way laws work in the United States. Like if you get pulled over and you're traveling 70 miles an hour in a 55 mile an hour speed limit zone, and everybody else is traveling 70, it's not a defense to say everybody else was doing it. Like selective enforcement is kind of the way laws work in the United States, probably everywhere else in the world.
I want to stay right here, I think, for a minute, just because of what happened this week. I had all the intentions of maybe going over the Loomis Gillibrand, looking at the United States and in the Middle East. We look at, and we have always from the early days whenever we were looking at New York State and then looking at a more federal level for policy in emerging markets in the Arab world, for example. So really wanted to get your take on what was happening in Washington, D.C. these days. But first, something that, happened in recent days that I think is speaking to your point is the recent allegations by the SEC toward, an exchange and sort of 9 assets that were held on that exchange. So this idea, that's the prime example of people accusing the SEC of regulation by enforcement. I'm not sure how to get to your point from there, because it seems like a really clear attack on these assets by way of enforcing this rule on this exchange. And I'm not sure how to parse that. What's your take on what happened this week?
So to be clear, the SEC did not charge Coinbase, right? So what happened was DOJ charged people with wire fraud for basically trading on inside information, making money because they knew that assets were going to be listed before that was publicly announced, and they used that information to trade for their own benefit. Wire fraud statutes in the United States are pretty broad. Doesn't seem that complicated. The curious part is the SEC, which for those people listening overseas, to be clear, the SEC is our federal securities regulator. We have a federal system in the United States. There are securities laws at the federal level, the national level, and then every state has its own state laws, which are called blue sky laws. But what's curious is that, yes, the SEC charged these people with the insider trading, basically, with violating regulations related to insider trading under something called the Exchange Act. And in order to do that, they said that these particular assets, and they listed a bunch, they said those things were securities and that these people traded on inside information. So those are civil charges. The SEC doesn't have criminal jurisdiction. Here's what's really interesting to me, and there's been some back and forth on this by commentators on the interwebs. The question is, okay, let's stipulate that it's bad and wrong to trade on information only available to you because of your employment to the detriment of the consumer trading public. It's bad for market integrity. It's not fair. But if you are a platform that allows for trading of securities in the United States, you have to register with the SEC. And if you don't, you get in trouble for failing to register. So what's interesting is that the employees were charged. Coinbase was not. The SEC, in its complaint, the document that charges people with violations of law, the SEC listed a bunch of assets that it says are securities. And it did a fairly detailed analysis in its complaint as to the components of those things that made them securities. Centralization of management, reliance on efforts of the management team, fundraising efforts, deliberate interest in listing those things on secondary exchanges, and so forth. So what's curious is that not necessarily that these people were charged, but it arguably, I don't know, there's like a cart before the horse issue. Like, why charge individuals with securities law violations when the exchange, which is much bigger, publicly listed, is still listing these things, apparently? I don't know, unless they've been pulled off.
But isn't that the actual definition then of the argument of regulation by enforcement? I mean, wouldn't that be the SEC defining these as securities? which prompted the tweet, which prompted the sort of meme generating Coinbase does not sell securities tweets.
I don't think that it's regulation by enforcement. I think it is, and to be clear, there's a technical term. It's called non-mutual offensive collateral estoppel. What that refers to is the use of a finding in one case against someone who was not in that case. In the United States, you generally can't do that. So even if the SEC manages to get a judgment, like gets a court to declare, it's upheld on appeal, that those assets were in fact securities, that finding is not technically binding on Coinbase because it's not a party to the case. And the SEC wouldn't be able to use non-mutual offensive collateral estoppel. It could be like very persuasive to a subsequent judge, but because Coinbase isn't a party to the case, there's a due process issue with findings or conclusions in a case that doesn't involve them being used against them. So they could fully litigate that later.
So two things. One, I'm really excited for when this podcast, we're translating into a few other languages. But then the second thing then comes to to that point of due process. I think that this is a really interesting thing in your work with DAOs that I was following over the latter part of last year when, talking about, or the application of an existing corpus of law, common law, for example, and the idea of arbitration of DAOs. So where does precedent establish, right? And then how do you take these existing laws that are arguably antiquated and then find our way out of this? If it's not regulation by enforcement, what is it? And then how do we find our way?
This is my favorite question, Mona. Thank you so much. The way law works, you hear people say law is like software, and that's not true entirely. However, it's similar to object-oriented programming. You have classes or categories, and qualities of those things are inherited by things that fall within the class. So it's sort of the way a common law system works. We apply precedent. And if you don't have a case that is factually identical or similar on point, you expand outward to find an analogy. So there's this great case from Tennessee in the late 19th century, maybe early 20th century. It dealt with responsibility or liability. So a child was electrocuted tragically and died because he came in contact with an uninsulated or improperly insulated overhead electric power line. And the question was, who was responsible for that? Was it the power plant? Was it the people who put up the overhead power lines? A bunch of other parties. The Tennessee Supreme Court had never dealt with this before. And, there was no precedent directly on point because overhead power lines was a new thing. No one had ever sued for wrongful death because someone had come in contact with an overhead power line. I had a case dealing with an overhead power line, 90 years later. In the latter part of the 20th century. And by then it was pretty standard. There were lots of cases, lots of laws. The court said, well, we've never seen this before, but we're not going to throw our hands up in dismay and walk away. We will apply some existing, precedent that deals with, liability for building stuff. And it did that, and it reached a conclusion. Now, in retrospect, more than a century later, the conclusion they reached was probably dead wrong. It didn't actually make any sense when you read the case. But that's what happens here. Courts they look for parallels and analogies. It's the way common law, it's sort of the magic of common law. It's the way it's worked for centuries and the way it will continue to work. It's kind of similar here. You're dealing with judicial interpretation of regulations which are promulgated based on or promulgated, regulations which are created because agencies in the United States are given authority by Congress and statutes. And courts they expand outward. If there isn't a case on point, they expand outward. To find authority, to find justification.
So you've been pretty critical of regulation by enforcement, and also the idea that the American regulatory body is somehow dysfunctional or not working. Where do you see that in context of, other ways of governing or regulating or maturing this space? Other nations, other regions, other trade sort of blocks. How do you see the United States in context?
If we're talking about crypto, blockchain, DeFi, we're talking about software, and we're talking about systems that need to be interoperable internationally if they're going to function properly and if we're going to maximize their utility. So my view is, again, I would challenge, I don't know that I've necessarily been overly critical of quote unquote regulation by enforcement. It's not a term, that particular term is not one that I love. But I think you have to step back and ask some sort of first principle questions. What is the point of the technology and where do the risks lie? Are the risks really ones that can be addressed by the disclosure regime that we currently have for securities? Or do we need something different? Do we need something better? And I think that question bleeds over into things like artificial intelligence, machine learning, semi-autonomous systems. We need a regulatory regime that addresses the technology risk, just like we have a regulatory regime that requires, if you want to build a bridge, you can't just go build it. You have to create plans. They need to be reviewed by an engineer. Plans need to be stamped. All sorts of things need to happen. Did you use an elevator today?
Yes.
Every time you get in an elevator, there is a little certificate up on the right that shows when it was inspected. And we can reliably build 120-story buildings now because we have a regulatory regime that addresses the risk associated with constructing, maintaining, and using those things. An interesting little historical tidbit, we didn't have high-rise buildings. We didn't have buildings in the United States that were more than 8 or 10 stories high until we figured out how to build elevators. And also, when elevators were first constructed in the 19th century, they didn't have brakes. They didn't have steam brakes, so they'd go up and then they'd fly down and people would die. So it wasn't until we figured out how to regulate these things that we were able to maximize their utility. And the regulation didn't prevent their proliferation. The regulation is the thing that made them possible. Regulation is not an enemy of innovation. I think one has to rethink that. You have to ask, what do we hope to get from this technology? And what is obviously having a securities law framework or rubric in place for elevator maintenance would make no fucking sense. But it does make sense to have, and I'm not an expert on elevator maintenance. I think you did have an elevator case once. But it does make sense to understand the risk associated with those things, identify them, and put in place a rubric that makes them work. Take electric lights. Take a lot of things that use electricity. Those things are tested by, if you look at a light bulb, it'll have the UL stamp on it. UL stands for Underwriters Laboratory, right? This is an insurance industry funded organization that tests electric products, right?
I was just going to ask you that was it the regulation that made it possible, or was it the maturing of the market into assuming or offsetting or underwriting a certain amount of risk? And does our industry, blockchain, or crypto and DeFi, or technology writ large, where's the role for that, I think, or where's that going to you?
It's a confluence of historical forces. And you have to Bitcoin's been around for 13 years now? Things take a long time. One of the things that drove me into becoming a lawyer was a fascination between the development of the printing press, the creation of copyright law, and the development of the novel as a genre. All of those three things are related. You wouldn't have the novel as a genre if you didn't have the ability to mass produce these things, right? If you had scriveners copying them one at a time, you wouldn't have the mass production of printed material. You wouldn't have had you wouldn't have had development of literacy writ large too. So there's this interesting tension between the development of technology, rules, because copyright rules limit reproduction, right? They create rights. These rules were in part created not to protect authors, but to protect publishers. It's really early days. And you have to first identify the utility. And it's not God bless them, Shiba Inu coin. It's not a lot of the dross that has made some people very wealthy that's interesting. It's other stuff.
Speaking of the other stuff, there's also a sense of, maybe the ethos, the idea of the decentralized economy, transparent autonomy, safeguards of digital extensions of rights and of privacy. So as the markets or as the industry become more regulated, and as those risks are offset in a way to allow for innovation to grow, what happens to those ideals?
I don't think most people believe them. I think they're mostly marketing language. I do believe, the notion of being able to control and self-custody your own funds is powerful. The idea that you can send value around the world without an intermediary is valuable and useful. Let's stipulate to that. so too is the notion of owning and controlling your own data as a consumer. Those are all really interesting and valuable use cases. Most of the time when I hear people when I hear people using words associated with community or decentralization, it's usually because they want me to buy something and take my money and put it in their own pocket. When I hear those words, to paraphrase, I want to say it was Harry Truman, those words, community, decentralization, ideals, ethos, I just generally don't believe it. I think there are some people out there for whom this is true. This is mostly a money grab, which is fine. I'm a capitalist. I'm okay with making money. But I think, for-profit ventures using that language is a tell for me. I generally don't believe it.
They're often associated also with, something that I've seen come up of late. We've seen in other sort of emerging technologies a few years ago, the idea of 4IR and what a body of ethics or best practices around, the use of AI would look like. And we're starting to see that, I think, especially in different governments when they're looking at, establishing perhaps their own digital assets marketplace or their own stable coin wrapped around their own currency. The idea that there's a metaverse ethics or a metaverse excellence center is often, those ideals and those words are often thrown around there too. It's interesting that someone like you, who I consider really idealistic and optimistic and yet eminently practical, it's disappointing. I'm disappointed that those words might actually really truly be relegated to a place of being a marketing ploy. Is there a chance that they might be encoded or embedded into a series of best practices?
I think I mentioned Jaron Lanier to you in conversations we've had before, Who Owns the Future. There is an optimistic utopian view of economies that are built on people being, I detest the term self-sovereign because it's abused so badly, but there is something like, if I could own my own consumer preference data, and remove 10 layers of middlemen, there's something about that that's interesting and maybe freeing and maybe a way to create a new economy. But that utopian vision has a dystopian side as well. Maybe it's being a lawyer and hearing from a lot of people who want to do things that are just pure profit seeking, but clothed in idealistic ideas.
I think, Jaron's work is really interesting because he was pretty critical of the market-based incentives that venture might bring, that a board of directors who had capital, market concerns might bring onto the technology, which I think about all the time when we talk about things. You touched upon this about is software law, right? And is the code the law, and how we might actually maybe be creating. And you've spoken a lot about this, and I think it belies your background as a technologist and as an inventor yourself. Who's creating the new markets and who's creating the new laws? Is it the code and the devs and the software?
No. And the notion that code is law is a misunderstanding of the Harvard law professor who, it's not Posner, the guy's name slips my mind at the moment, but he wasn't actually saying code is law. When people say code is law, what they mean is that whatever result a piece of software spits out, you're bound to. And that's just not the way our legal systems work. Now, there are ways to create automated financial contracts that provide automated solutions, which might remove a piece of the dispute terrain, if you will. I don't necessarily agree that just because software executed a particular way, that's the correct result. Just because terms of service, for example, say that bound by the result of a piece of software, don't make it actually so. And I don't think that software will supplant law. It might remove disputes in certain contexts. So you can imagine an automated insurance contract that pays out if certain conditions take place. We've seen that. We've seen those things built by people in crypto. And part of my background is an insurance lawyer, so I find that fascinating. I think we're on the way there. It'll take a long time before those policies can pay automatically for anything more than one or two parameters. But, that's going to happen. We will see insurance being automated.
I want to code a utopia into the future. And I think that when you look at some of the practical realities of what the industry brings, it would be mealy-mouthed to not talk about the widening disparity, the widening income gap, about, the environmental or economic tolls across all markets, across all regions, and then particularly exacerbated by certain industries. I know that, the crypto one's not immune to that. Is there a way, while all of those things are happening, to maybe not just raise the ceiling, but also raise the floor of the human condition? If we are not being naive or in a sense of being utterly pragmatic and realistic, how might we still work toward those ideals?
Look, the problem that most people have in the world is like access to clean water, being protected from people with guns and machetes. Can blockchain get people clean water? I'm sure there's somebody out there listening to this who's going to be like, yes, blockchain can do that. But, I'm sorry, it's not correct. If you want to make the human condition better, we need guaranteed medical care. The idea should be that like food and water are a human right. I just think that the problem space is so much larger than what software can solve, or what lawyers like myself can solve. So we're in the early part of the 21st century, and we're looking at devolution, right? We're looking at countries, economies, nationalities separating as opposed to coming together. And your idea of elevating sort of the human race, it's an interesting vision, but the question is, how do we begin to think about doing that? I don't think I'm smart enough or advanced enough spiritually to answer that question.
It's so funny? When I first saw the very first, now all of the ads for like Apple products, when I remember seeing those early ads, it was exactly Hess's book that I remember seeing, that sort of religious, that beatification of technology and the way that it was presented. And Steve Jobs would come out as sort of, the priests of the true faith of great design. And it's interesting that somehow new technology or new innovation is always imbued with this sort of moral obligation to make the world better in a way. And so the onus on our industry seems to be kind of part of that.
It's the same thing like in Asimov's The Foundation trilogy, the engineers become priests. You see this in crypto too, this sort of deification of the designer, the creator, which, I've written software before. It's fucking cool. And you actually feel like when you get good at it, you feel like you've captured fire. You've captured fireflies in a jar. It is an amazing, amazing feeling. But it is from a moral or ethical standpoint, it's not neutral necessarily, but you create normative value within that software by how you use it, how you implement it, what you focus on. I discovered when I started building this stuff, you can become a software developer, designer. I know people like to call themselves software engineers, without studying ethics or morality. And what I discovered too is, you have brilliant people who know how to build things that have that can have significant consequences on people's lives, aren't necessarily given the skill set to help make decisions about ethics. But those decisions are foisted upon because nobody else will make them.
I tend to think there's a whole school of modern philosophy that's based on the idea that the moral compass of humans is shifting as our technology, sort of integrates within our daily lives. And the idea that you might be able to map patterns of us versus them on top of our right versus wrong. That idea that people don't like to share is one that really deeply resonates with me, Stephen.
Take Bitcoin as an example. It's cool. Like you can use it to escape from a country with your wealth. You can use it to send remittances to people in, other countries. The technology is not an end all and be all. We have to look at how it's used, who uses it.
So there's a few things about my early blockchain years. One was my sort of OG blockchain stack was pretty much all women. The second thing was that I got to see really cool stuff being built in the Middle East for a while, but in Africa, which, I hate saying as a sort of monolithic place, but really for all of those innovations that I saw in Nigeria, for example, or in Kenya, I saw kids sending Satoshi over radio waves, and I didn't really see a lot of people who were using it for clandestine communications to launder money and to sponsor, acts of state or national or global crime and terror. And so can we talk, we face that all the time where it seems to be a misnomer, and especially in what we consider rising markets. I mean, I just don't see that to necessarily be the case or the functional use case.
Just to be clear, my point is that the evolutionary use of the technology depends on people, policy. I can imagine a world where there is basically a transnational, supranational currency, and where it happens that it's based on Bitcoin, uses Lightning. That's certainly a vision of the future that's possible. I think it's also quite possible that the notion of stablecoin will be co-opted by state actors, and you'll have central bank digital currencies. I mean, money is already basically electronic. It's just one step in the same direction using that technology. Whether or not that helps bank the unbanked really depends on policymakers. Suddenly, you also have a question like, let's say cash in the United States goes completely digital. It's a central bank digital currency. Well, that means everybody's going to have a phone. How are we going to do that? We're going to we're going to give everybody phones? How many? Like, what model? Like, how is that going to work? There are these basic technological hurdles. Does that mean a 10-year-old's going to have a phone? Like, kid goes to a candy store, they're going to have a phone to buy stuff? There are some, threshold policy issues that you have to work out.
In emerging market indices, we'll often talk about how, for example, in the Middle East, we have an overwhelmingly young population. A lot of our countries are somewhere around 70% under the age of 35. And most people have over 2 phones per member of that particular population segment. So it's interesting, the idea that, blockchain adoption, or that, these sort of frictionless networks are on top of this overwhelming tech integration at kind of all socioeconomic. And in the United States, it's always shocking to me how many, for example, displaced and homeless people there are. And then 2, when you walk by a restaurant that's cashless only, I'm always mindful of the fact that you can't give someone $5, that the idea that they'll be able to redeem that $5 for foodstuffs is diminishing. And then 3, have you started to see people with QR codes for their Venmo on the street soliciting money? So it's interesting to think about that.
You talked about DAOs earlier, and this kind of goes to your question about the future. Now, most DAOs end up creating a lot of problems for themselves because they don't take governance seriously, and then suddenly you're sitting on top of a couple $1 million in a multi-sig, and suddenly everybody's freaked out. However, corporations don't work perfectly. They are a solution to a coordination problem. Once you have people in the space who, A, understand corporate law, B, understand governance, C, understand ways to improve the coordination problem. I'm starting to see this. Like, people with experience coming into the space, they're like, yeah, Steve, we know. DAOs are stupid. We get it. We see all the problems. But what if we could use part of the technology to help make existing organizations work better? I think we will see some interesting innovation in that space. It's just a question of getting the right people to collaborate. So you'll need lawyers, you need software developers, you need you need people with expertise in governance, you need people who've spent time in large organizations. You put all those people together, and maybe you can actually improve the way corporations work, because they don't work perfectly. And there are things that happen in corporations where significant discretion is granted to individuals, and often they don't exercise that discretion perfectly. Software can make some of that work better. So I definitely see that as one space where we'll see innovation. Now, if I was investing in the space, I would be looking at the people who were involved in these projects and asking about their experience. It's great to have somebody who is brilliant at one thing but doesn't know the other thing, and who brings to the sort of the coordination problem space like a beginner's mind, that innocence. Like, why is it done that way? Like, does that make sense? Like, why not do it a different way?
It's like that mixed with some sort of common law, almost like a DAO prenup.
I think the concept DAO is so overdetermined with dipshittery at this point that I'd almost rather not use it. Like, a corporation is actually a decentralized autonomous organization. A corporation is a person in the eyes of a law. Corporations, they're the first robots. Lawyers invented robots, right? It is an artificial person. It has status in the eyes of the law. So the question is, how can we take that thing, which, derives from the 18th and 19th century, and how can, with the knowledge and experience we have in the last 300 years, 400 years, or thousands of years of human coordination, how can we make it better? And how can the concept of the DAO, I'm going to deprecate it now, it's a dumb term.
What would you call it? Would you call it a corporation?
The thing about corporations that are useful, and by corporation I include things like a limited liability company, an LLP, whatever, like corporate bodies corporation limited by guarantee. They do cool things. One, they protect owners and people who are involved with them from personal liability, the corporate shield. That's useful. Two, they have some tax benefits because they are separate in the eyes of the law. So I think if you can start with the concept, protection from liability and tax advantage are good. You start with those principles and you think, well, what about the entity can we make better? And how does software fit into it? Then it becomes a useful inquiry. Like, what are things about corporations that don't work? The answer to the question is a question. And the question is, what's the problem you're trying to solve? Some of the people who've approached this have been like, yeah, corporations are all bad. We're just going to throw it out and sort of reinvent coordination from the beginning. And I think that's ass backwards.
Are there certain cases then, since we're looking at, in the spirit of deprecation, are there cases out there that are interesting? Are there laws that are around DAOs that can go either way or that would be interesting or that have evolved the way that you felt about, your work in DAOs since like 2018?
I mean, no, I think the Wyoming DAO LLC statute is a bunch of, it's sort of legislative theater. There's another state that has a DAO-related statute too. I don't really think any of that's terribly useful. But, it's not really fair to say that, let me correct myself a little bit. A lot of innovation requires failure, experimentation and failure. So I want to commend the people who put a ton of work into those things. I don't think it wasn't wasted work. I don't think that the answer is there yet in those particular statutory experiments or regimes.
So other than some sort of weird hybrid DAO prenups, are there any interesting use cases or any interesting places in litigation law that you see being advantageous to or being advanced by blockchain? Or are there any places where there's precedent being set in American law that are furthering the industry?
As to furthering the industry, I'm not sure about that. I mean, there are some interesting questions we're going to see raised in these large bankruptcies about who owns crypto when you send it to or transfer it to an exchange. What is a depositor? Are they an unsecured creditor? Are they a secured creditor? Are they something else? Those are all interesting questions. They're going to be sorted out. We actually just filed a lawsuit in New York to recover 2 NFTs. It was a John Doe lawsuit. And we filed using something called in rem jurisdiction. It's kind of cool. I have lawyers out there will understand what I'm saying. For that case, the question was, well, where does an NFT, like for jurisdictional purposes, where does an NFT reside? In other words, if these things are everywhere, like if you can find a node in your state, does that mean you have jurisdiction over the res or the thing? So that's an interesting question. I think we'll be seeing some interesting case law or development there. From a solution standpoint, I think I've told you this story, and I've told this story on so many podcasts and presentations. I don't want to go through it again, but dispute resolution. There is a great opportunity here to create automated solutions for resolving disputes. Litigation, and I'm a litigator and a trial lawyer. I love being in court. It's exhilarating. It's fun. I love the way a courtroom smells. I love the theatricality of it, the advocacy. I love helping people get fair solutions. But let's face it, the way litigation works in the United States is terribly inefficient. It puts food on my table, but I think we're going to see a software solve for a lot of the inefficiencies in disputes. And I think that there are ways that distributed automation uses distributed systems, whether you call it blockchain or something else. I think that there are some incredible opportunities there.
You know what, Palley? I just realized your focus on dispute resolution, not only in your practice of law, but that's something that I'm not sure many people know about you. I don't know if you tell that story a lot about how you came to learning about Bitcoin, but you yourself were inventing something a decade ago focused exactly on this, correct?
Yes, that's exactly true. I built a dispute resolution software platform, learned to program, nearly bankrupted myself, learned about social media. I ended up repivoting to focus on law because that's what I know how to do. I didn't know anything about raising money or digital marketing, but I ended up, doing work for other software developers and became a technology lawyer. But yeah, no, dispute resolution, the way we do things in the United States, it's terribly inefficient. The way we negotiate, it's terribly inefficient. It just doesn't make any sense. Usually it's these things, particularly in the civil context, there are cases where people have been morally wronged, like criminal cases, certain types of fraud, to use the process to work emotion out, but often these things are just dollars and cents. And that's basically what I focused on. I built a system that allowed people to get past the lack of trust in each other, a lack of trust in the process, to just figure out if there was a way to economically resolve something and do so quickly. And that's actually how I discovered Bitcoin and then Ethereum before the initial sale. I think there's a lot of room there. And that is the thing, like, I love that. Voyager, Celsius, exchanges I haven't heard of. It's quite tragic. And that's actually not work that I typically do. And often the funds the amount at issue is small enough that it's difficult to find a lawyer who will take those cases. But there's a lot of bloodshed and tragedy in the space right now.
So it sounds like the app might have been a bit early for 2014, but right at home in 2022.
Always been too early. That's the story of my life.
Well, you're not doing too bad for a simple country lawyer, Mr. Palley. Do you it's interesting. It's such a unique amalgamation. Sometimes I think of you more as a philosopher, and probably because of the herring stuff. Somehow, I don't know if it's because of the way that you tweet yourself, but you give me a sort of Little House on the Prairie country lawyer, the simple country lawyer vibe that you're often.
Must have been my time in the Midwest. And actually, I grew up in a small town on the East Coast a long time ago. And the town was a place, we had a main street. And you always said hello to people when you passed them in the street. Procter & Gamble used to do some of its market testing there, Newark, Delaware. That's where I grew up. So I don't know, maybe.
Has it made its way into your practice? There's definitely a folksy vibe. I think this idea, this eminent practicality.
People misunderstand the role of a lawyer. And to be good at what we do, it's that like Buddhist beginner's mind. Like you have to ask a lot of seemingly dumb questions and not be embarrassed about it. Like questions like, what do you mean? Why? Where? Who was involved in that? When you said blah, 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 I'm sorry, I just didn't understand. I must not be smart enough. Can you explain it to me like I'm a 10-year-old? Like that's the way to be good at what we do, is to ask people a lot of W questions. It's not a trick. It's part of the practice.
Sometimes I know that you have a certain ritual that you undertake if you're writing an opinion or writing a lawsuit. I know that it probably involves poetry or you're playing something in the background. You have these sort of ritualistic parts of your practice that I think and not many people know that you were also an English lit major, I believe. Is that right? What are you carrying from those days into your simple country law practice?
I was working on a PhD in English when I decided to go to law school. I didn't find the academy to be a suitable place for what I think is eminent practicality. And also I like eating, and I'm not really sure how well English professors eat. So I really like poetry. I love music too. And at the time it was all studying like French post-structuralist philosophers like, Derrida. I just never, I don't mean this in a sort of glib or falsely self-deprecating way. I actually heard Derrida speak. I pick up some of his books, like I have them in my basement. I pick them up once a year and I look at them and I'm like, I just don't understand. So I just wasn't a good fit. And I went to law.
So is it a good fit for someone to be leading the charge? Yeah. A blockchain lawyer.
Yeah. The great thing about law, and particularly like working on disputes or like helping people avoid them, is it's a good fit for somebody who is either peripatetic. It's a good fit for somebody who's either peripatetic or a dilettante, depending on how you look at it. You're always learning about new stuff. If you're a curious person and you like finding out what other people do, it's really cool because you get to see how airport conveyor belt systems are built, or how financial systems work, how an ATM works. I still know how the Portland cement insulators on top of electrical poles work because I had an electrocution case when I was a baby lawyer. You learn really cool shit, and then you can either forget about it. I know a lot about railroads and PCBs from a case I worked on. It's cool, and you get to people tell you their stories. It's really fun if you like narrative and stories and you're a curious person. The problem with law is it's really easy to get beaten down by disputes. You have to be able to deal with unpleasant people and disputatiousness.
What are the cases that keep you curious in modern technology or in these emerging technologies? And maybe not on the dispute side, but what is making you excited and curious to think about now? If it's the same kind of thing, what's the electric pole or the elevator that's being built today that has you puzzling?
I could say machine learning and AI, which I do actually I've been fascinated by, and I think will completely change everything sooner than we think. Do you know Stanislaw Lem? It's about a poet who creates an AI that is supposed to write poetry. And he programs it with like every bit of human literature. And anyway, it's a story about what happens to that software. At the end of this, I don't think this is a spoiler. It's still wonderful. It's translated from Polish by a wonderful translator. In the end, it has to be dragged off to a star far away because it's so disruptive, right? Because it knows everything. It can prevent people from disassembling it because it can make them feel bad. So obviously, I already feel like my phone. I wanted to know about platypuses this morning, and I just went to my phone and looked up platypuses, and boom, it's right there. It's something about that for sure, but also, I find power generation, like solar and nuclear, really fascinating. Allowing people to create their own energy, carbon capture, and repurposing carbon. Let's try and be optimistic. At the end of the 19th century, cities were literally drowning in horse shit, right? It was a massive problem. 20 years later, the horses were gone and we had cars. Cars created a new problem, of course. I think anybody who doesn't believe that global warming is a thing is either delusional or a liar. But, the question is, what if there was technology that allowed you to take carbon, excess carbon out of the atmosphere and repurpose it into other things? Alternative energy sources, I think, are really interesting and could be really transformative solutions to global warming. Obviously, AI, autonomous systems. The use of those things for dispute resolution, also really interesting.
Who are three of the most influential people in your life, Mr. Palley, and how do they impact your day-to-day?
A judge who was my teacher in law school named David Mason. He's a circuit court judge in St. Louis, and he taught me how to be a trial lawyer. He was the most generous, brilliant teacher I've ever had. And more than 20 years later, when I stand up in court and button the top button of my jacket, I think of him every single fucking time. And he's an example of the impact that a great teacher can have.
Do you have a favorite quote?
I've got a lot of favorite quotes. To seek, to strive, to find, and not to yield, at the end of Tennyson's Ulysses. I love that. We'll go with that.
Stephen Palley, I am so lucky to know you, and thank you so much for spending your time with me today.
Absolutely.
Our time is up for now, but the conversation is still going. Make sure to follow us on Twitter at SinoGlobalCap, subscribe to our YouTube channel, and leave us your feedback so we can loop it into upcoming episodes.